Now, I have a few questions that I want to ask you. So you mentioned the word brief. Does that mean legal argument? Is that what that means? The word brief?
No, it is actually, if you look under the family law rules, everything on conferences is under Rule 17. So if you want to look at about conferences, you just look at the family law rule 17 and it will tell you everything you need to know about conferences.
Super.
The case conference brief is an actual pre-formatted form. You can download it from the Ontario Courts of Justice website, or if you go to like the Steps to Justice website, the brief forms are available there. So it basically is, they're like any of the court documentation. It is a court document. You download it, you fill in the blanks, you put information in the paragraphs where they ask you for it, and you follow that format. So the brief just basically, again, it goes through, quite often it'll repeat the claims that are made in the application or the answer to say, okay, I want A, B, C, D. The other party has said they are looking for X, Y, Z. I have a claim for support. This is the financial documentation I haven't received yet. This is where we want to go. This is what I'm proposing. I think the kids should live with me, but I'm prepared to let the other party have them every other weekend and one night in the middle of the week. I'm not sure what the other party feels about that, but I'd be prepared to settle for that. So you're basically, in your brief, you're telling the judge what you think are the issues that need to be discussed at the case conference and any proposals you have for settling any of those issues. And if there's stuff that you still think that you need because the other side hasn't produced what they were supposed to produce, then you set that out in your brief too, saying, hey, they didn't give me the rules, say that they got to give me their last 3 years income tax returns. They haven't done that. So that's a heads up. So then the judge knows what's going to be dealt with at the conference. Okay.
Super. Okay, one last question. I've heard of something called a dispute resolution officer, or DRO. Because you mentioned like judges sit on case conferences, and now I'm confused. Like, who are the DROs, and are they the same? Like,
okay, in some jurisdictions we have DROs, dispute resolution officers. They basically, again, it's trying to make as much use of the judge's time as you can possibly get the highest and best usage out of it. So in some jurisdictions, they found that there were, despite what the rules say for what you need to do to be prepared to go and talk to a judge at your case conference, especially with the number of self-represented people, it just wasn't being done. So it was a total waste of the judge's time. All the judge could do at the conference was make all kinds of orders and say, now do all the stuff that you should have done without me telling you to do it, then we'll come back and we'll deal with it on another day. So in some jurisdictions, they created a system called the Dispute Resolution Officer Conference, which is a case conference or a settlement conference. I guess usually you tend to see them mainly in case conferences, but what they do is they basically triage the case conference. So they do a dry run. They go through it with the DROs are usually very senior, experienced family law counsel in the jurisdiction. And they come in, so they're basically doing the same work that a judge would do, but they're not a judge. But they're there to make sure that the parties have done everything they need to do. A DRO cannot make any kind of orders.
I see.
Because they're not a judge, but they can go through, make sure everybody's done the documentation they have. If there are issues that need to be flagged for disclosure, and if everybody agrees, okay, before we see a judge, yeah, this disclosure has to be done, then the DRO can set timelines with people for when disclosure is expected to be made. But it's basically tying everything up in a pretty red bow. So then when they do come for the case conference in front of a judge, the DRO has already triaged it and dealt with maybe some of the procedural stuff and got people organized and set so they can really use their time when they go in front of a judge.
So is this optional? Like, I mean, or is it just based on, you said jurisdiction. So if it's available, but do people have to use DROs, or is it just an option?
Again, it depends on the jurisdiction. Some will automatically say that if your case conference is set and you do have DROs in your area, that your case conference will go before a DRO. Or if there are some jurisdictions where it's optional, and people can either say, well, we'd like to do a DRO conference before we actually do our case conference. So it's something to check with your individual court office. They'll be able to tell you and let you know.
Sounds good.
But it still doesn't matter. You'd still have to do your case conference brief. Like, you do everything the way you would do it as if you're going in front of a judge, but just it's a way of triaging what is going to go before a judge with a very senior member of the bar who cannot make an order because he or she's not a judge, but they can get all the stuff organized and get schedules in place for disclosure, so everything is done for when it does get before a judge.
Oh, that's really nice. That's just an additional service, right, that the court provides for
It
people.
is. It's trying to make sure that people are as prepared as possible for
Mm,
their court appearances and that they really are thinking at every step of the game, is there
wow.
something we can do to resolve an issue on consent rather than leaving it to get
Yeah,
decided by a fight?
of course. Wanted to talk about the atmosphere because you mentioned that the conferences are more like of an informal way, right? Of the people to the different parties
Mhm.
and the judge to get together. So you said that you still have to have the conferences held in a courtroom, or is it in the chambers? Like which one?
No, you are still, your conference will still be in a courtroom.
A courtroom.
The judge will be there.
Yeah.
Depending on the judge, some judges will participate in the conference from the bench where they would normally sit to hear an argued matter.
Yeah.
There are other judges that will actually make the court staff rearrange all the council tables so that they're in a U or a circle or whatever, and the
I
judge
see.
will come and sit at the table. It's really the judge's preference, but even if the
Oh,
judge participates from the bench, it's still, there's no court reporter present. Like I said, nobody's giving evidence. Nobody has to stand up. And nobody, if you have counsel, it's not a proceeding that the counsel needs to be gowned for. You just wear
oh,
professional clothes.
oh.
So it's just, yeah, the parties and their lawyers coming in and speaking to the judge. So it's not recorded. Like I said, there's no court reporter there. The whole point of the exercise is to encourage people to talk with each other and try to see if there's a way of settling it. I've seen judges at case conferences and settlement conferences that will turn to a party and say, you know, you have absolutely zero chance of getting
Mm,
what you're asking for if you proceed to
mm,
trial.
mm.
You're setting yourself on a path that is, you're never, it's, you're going to lose. If you take this position at trial, you're going to lose.
Right.
Now, there are some other options, things that are available to you. So again, it's a means of trying to explore all this to see if you can get somebody to really understand what's
Mm.
happening so that they know where it goes. So yes, it's not being recorded. It's not a formal hearing where people have to take an oath and swear to tell the truth and they stand up and give evidence. It's people are seated, conversation goes back and forth, but it is not reported. There's no recording done of what happens in a conference.
And I assume, of course, if I need a friend to come with me for moral support, I'm definitely probably allowed. Definitely, probably. I'm
You can
probably
bring a support
allowed to
person
have a
with you,
support
yes.
person. Yeah.
Yep, yep, that's not a problem. There are some people, again, we're talking about family law, so there are quite a few situations where there have been very traumatic examples
Right.
of domestic violence that have
Yes.
occurred.
Right.
And you can actually have professional support people coming in,
Oh.
like the family court domestic violence clerks can come in. So
Oh.
the support workers, there's actually family violence court support workers that will come in and attend with the person at a hearing or at a conference or whatever. So
Wow. I didn't even know about that.
yeah,
I
you're
heard
not
of
allowed to troop in like your whole family with you, but yes, you
no.
can have
Right.
a support person with you. And of course, if you
Right.
have counsel, then your counsel can be with you as well. But as I said, you are expected to be there in person and attending.
I have a question about draft orders because I think you said that the conference judge, they are allowed to make an order, of course. So now I'm coming from civil side, but usually the parties or the council, they have what's called a draft order. Now, is that similar in family cases where if there's no order, it's really the party or the lawyer who drafts the form of the order first, and then they give it to the judge to sign? Is it like that, or how does that all
It's
work?
it's flexible because the whole point
Ah,
of the conference, especially the case conference, you're really early on, so you really probably are not quite sure exactly what's going to happen. But if you're feeling optimistic as a party,
mhm.
you can prepare a
Yeah.
draft order dealing with
Ah,
everything that you want and what you're prepared to agree to,
right.
in the hopes that the other side will say, yeah, I'll agree to that. And you might not get them to agree to everything in your draft order, but you can do most of them and you can redraft it.
Oh, cool. Right.
Um, Again, some judges, like in Hamilton, we have one or two who are just absolutely amazing with their computer. Like they'll be sitting there and while the discussion is going on, they'll
Yeah.
be talking and typing out an endorsement at the same time based on what people are telling them they're agreeing to.
Right.
And then the parties will actually get a typed endorsement from the judge
Right.
when they leave it. And then they can take that endorsement and have it turned into a court order.
Hmm.
There are other judges where if it looks like there's a number of issues that can be settled and the parties said, yep, we can agree on this. Yep, we can agree on that. Yep, we can agree on that. The judge will recess the conference and say,
Right.
okay, I'm going to go do something else for a while.
Right.
Come back in an hour, come back in an hour and a half with a consent or minutes of settlement and a draft order for what you've already agreed to. And then the parties can then work on it on their own, get it drafted out there. There's, if you got a lawyer, there's counsel rooms at the courthouse where they can get access to a computer and they can type out minutes of settlement or a draft order or whatever. And then they can come back in after the recess and present what they've agreed to the judge. And the judge will then just make, the endorsement will be ordered to go in terms of consent or minutes of settlement filed.
Okay, you just mentioned something that I'm going to ask a really stupid question. And judges always say order to go. Like, what other kinds of orders are there? If it's not to go, then what is it? To stay? Like, I don't understand. What does this mean? Order to go?
It's just part of the dialect. It's the same as saying an order shall be issued on the following terms.
Oh, an order shall be issued. Okay, I understand.
Yeah, okay. Yeah,
okay,
I've made a decision. It's either on consent or it's not on consent, but this is my order. And so this is what the order is going to look like. But like what the judge does is an endorsement, not the actual formal order.
That's right.
So that's what it is. Order to go.
Yeah.
Is the same as saying an order shall issue on the following terms. Some judges say that, some just say order to go. That's generally all that it means. And the other question I think that you had as well is keeping in mind, because there are so many self-represented litigants in family court. Like, what happens if the judge does an endorsement that says, okay, an order shall issue on the following terms. And let's say the judge actually writes out or has typed out all the terms of the orders that the parties have said they've agreed to, but both parties are, okay, if either side has a lawyer, it's up to the lawyer to have the order issued and entered, even if they're the one that maybe didn't get what they wanted, but as long as there's a lawyer there, the lawyer is supposed to do that. If 30 days has gone by from the time the endorsement was made, then either party can bring a motion to have the order taken out, because if somebody is stalling and not getting it done, but an order is effective right from the day the endorsement is made. Like, all you're talking about is getting the formal issued document in your hands. And if the judge made an order on that day, that order starts and it's in effect from that date that it's actually made. If both parties are self-represented, again, under the rules, the court staff are supposed to take the endorsement and draft the order and issue it and enter it and send it to the parties.
How nice.
Staff are being run ragged. This rule's never really been properly applied because they're just too busy. There's too much other stuff going on. I've known people, if they really wanted to have the formal order issued and entered, they will just take the endorsement and bring it to a lawyer's office, unbundled service. They can take it to a lawyer's office and just say, can your staff take this order and prepare it in a form that I can bring it back to the court to get it issued. So you can just pay a lawyer to just actually do the actual order based on the endorsement.
Yeah, it's always interesting that judges just give endorsements. This part always trips me up. Like, when I was new to the whole, I still feel like I'm new to the system, because I cannot really understand. Like, you go to court and then you ask for an order, and the judge is like, all the judges go give you the endorsement. You're like, why can't you just do the order?
Well, part of it is, and again, you really see this in family law, because let's say that the parties agree that mom should be paying dad child support of $300 a month for 2 children based on a gross annual income of $29,000. Okay, that is a child support order in accordance with the child support guidelines. There are like 4 paragraphs that are mandatory, that every time the court makes a child support order, there are 4 paragraphs that are required to go into an order. And the judge isn't going to sit down and do the boilerplate stuff that has to be included in every one. It'll just be, okay, child support in accordance with the guidelines. And then whoever is doing the draft order knows that you have to do it. Like, again, that a copy of this order is being filed with the Family Responsibility Office, that the Family Responsibility Office will be responsible for the enforcement of the order. Like, there are standard form paragraphs for a lot of different things. You're not going to, the judge isn't going to waste their time doing it, because they go in every order when there's an order for child support made. But you're not going to make the judge write it out all the time, every time he does an order. So
Right. I mean, this all makes sense for the traditional way, which was a lawyer-led system, right? And I mean, in the old days, hardly anybody self-represented. But these days, a lot of self-represented. Well, what am I supposed to do? I don't know any boilerplates, So I just kind of like thought that was interesting. Okay, almost like final question now. Actually, it is, I think, my final question. I know this happens sometimes that if your other side is a little bit difficult, let's say, right, not cooperative, can you contact the case conference judge and say, oh my gosh, the other side is just like, maybe sending me harassing emails or that kind of thing? I know.
What you do is you put it in your brief for your next time when you're in front of a judge.
Okay.
Yeah, you can't contact the judge in between the matters. That's what you hire a lawyer to do, is to make these kind of complaints to. But no, the judge is there to assist you at the conference. But once the judge is done in the conference, you can't contact the judge in between. And it may not even be the same judge that's coming up the next appearance that you've got. But any grief you get from the other side, if they're being a jerk, if they're not doing what they're supposed to do, all that information goes in your brief. And the next time you're either in front of that judge on your next conference, or even if you're going in front of another judge,
right?
But for your conference, you put it in your brief. So that judge is going to have that information available. And again, it's not even an affidavit. It's not sworn evidence. You're just saying, okay, this is what's happened since the last time we were at a conference.
Oh, interesting. But are you allowed to bring a motion? I know in the civil side, people bring motions all the time. So in family cases,
you cannot bring a motion until you've had your case conference with the judge.
So let's say you did, right? Well, so let's say you did have that first case conference, and there was like an order to compel the other side to disclose financial disclosure.
Or pay child support.
Or pay child support or whatever, and they're not cooperating, right? Can people bring a motion?
Yeah.
Okay, so they are allowed.
Once you've had your case conference, you can knock yourself out. You can bring a motion pretty well for whatever you want. Okay. It's just the problem used to be is that people said, I don't have time to wait to get before a judge on my case conference. I need an order for custody now. I need an order for child support now. And the way the rules are set is saying you can't unless you have an urgent or an emergency issue. And there are very specific requirements for what constitutes an urgent or emergency issue. Like what you think might be an emergency or urgent isn't considered an emergency or urgent by the court. And they actually now, just in the last couple of months, they've implemented a triaging system in family court, that if you are trying to bring a motion before your first case conference, it will actually go to a judge in chambers who will triage the motion.
Got it.
And then there will be that judge that said, yep, this motion should be scheduled to be heard, or no, this motion is not to be accepted and shall not be proceeded with until after a case conference is heard.
Understandably. So just in summary then, after the case conference, you could bring the motions, but before the first case conference, you can only do so to bring a motion if it's urgent or emergency, right? And they get triaged in those cases. Got it. Okay, sounds good. Okay, I think that's it. Do you want to have anything to add? Any last words?
No. Again, we spent far more time talking on something that is relatively boring than we expected to. No, I think we pretty well covered everything that we said we would talk about. I think the key message to get across that people should just keep in mind is this is not just a hurdle to jump over to get you to your trial. The case conferencing system is designed to try to encourage settlement because, again, any order that is made that the parties been able to work out and agree to themselves is far more likely to be followed than an order that is made by a judge by hearing argument from two sides from people who don't agree on anything.
Yeah.
So the whole point is to try to get people to resolve issues where it's appropriate to do so. And you've got to be prepared for it. You can't just not think about your case and then go on the conference and see what the judge does. You really need to work to prepare for it.
That's a great tip. So thank you so much, Helena, for sharing your knowledge with us. And for those of you who are new to this channel, don't forget that Litigation Help also has a website and it has additional resources and services for you to consider. And thanks everyone for joining us today, and we'll see you at our next video. Bye.
Bye. Thanks, Heather. It was fun.
Great.